Victimology, Theories and Applications, Chapter 5, Justice Systems. Case example, murder of Caylee Marie Anthony. 2-year-old Caylee reported missing 5 weeks after she disappeared. Found dead 6 months later. Evidence found in mother's trunk. Casey Anthony acquitted of murder and lying to police. Greek mythology. Zeus, a god who gives justice to man. A standard of right and wrong is introduced. Punishment for those who do not act in a just manner. Those who do not help others sin against Zeus. Zeus is the protector of the weak. The Code of Ur-Nammu. The oldest known tablet containing a law code that survives today. Differentiates between levels of crime and victimization. Monetary compensation for bodily damage as opposed to the later lex talionis, an eye for an eye, principle of Babylonian law. Capital crimes of murder, robbery, adultery, and rape were punished with death. Uru-Kagina reigned 2380 to 2360 BC in Mesopotamia, sometimes cited as the first example of a legal code in recorded history. Exempted widows and orphans from taxes, compelled the city to pay funeral expenses, decreed that the rich must use silver when purchasing from the poor, and if the poor do not wish to sell, they could not be forced to do so. The Code of Hammurabi, first ruler of Babylonian Empire, restored order and justice to Mesopotamia. Code was established circa 1786 BC in ancient Mesopotamia. Code governed family, criminal punishment, civil law, ethics, business, prices, trade, and every other aspect of life. Purpose was to promote the welfare of the people and cause justice to prevail by destroying the wicked and the evil, that the strong might not oppress the weak. Mosaic Law. The 10 Commandments given to Moses by God in 1300 to 1100 BC. Mosaic Law begins with the 10 Commandments and incorporates aspects of the Bible or Torah. Provides the basis of Judeo-Christian morality and many of the criminal laws in our modern society, for example, the prohibition against murder, theft, and perjury. Roman Law. Developed over 1,000 years from 449 BC to 530 AD. Earliest of Roman laws was the 12 Tables. Governed all spheres of law, private, criminal, public, and sacred. Written in response to the plebeians' protests that the patrician judges were able to discriminate against them with impunity because the principles governing legal disputes were known only orally. Code of Justinian. Byzantine Emperor, commissioned law review. Book 1, Codex Constitutionum, collection of decrees of the emperors. Book 2, the Digest or Pandex, summary of 9,000 opinions of the lawyers and judges who had interpreted the decrees. Book 3, textbook, legal principles in simple terms. Book 4, the novels, novella constitutions, the new ordinances of Justinian law. Feudalism, enforcement of law and exaction of taxes, not by the state, but the landowners. 8th century France, estates granted in exchange for military service. English feudalism, a system of rights and duties binding nobility to the king in exchange for land, fiefs, worked by the peasant labor, serfs. America, proprietary colonies established in New England. English common law, traditional unwritten law of England that is based on custom and usage. Legal decisions provide precedents for the courts and lawyers to follow. Became the basic law in the United States, based on the Commentaries on the Laws of England completed by Sir William Blackstone in 1769. Today common law is enacted into statutes of all the states except Louisiana, which is the Napoleonic Code. Magna Carta, the Great Charter of Freedoms, a 13th century document that is regarded as the foundation of English constitutional liberty, first document forced onto a king by his subjects. It required that the king, John of England, be bound by legal procedures and legal decisions, afforded rights to subjects of the king. Contemporary codes and laws. Magna Carta, common law. Constitution established individual rights, defined the powers of the federal government, and limited punishment for violation of laws. Canadian Constitution set out basic principles of democratic government and is the supreme law of Canada, state and federal legislation. Criminal law, concerned with actions that are dangerous or harmful to society as a whole, in which prosecution is pursued by the state, defines what constitutes a crime and prescribes punishments. Governed in Canada and the U.S. by feudalism, that is, the power to govern is shared between national and state governments. Levels of U.S. court system. District court level. Here, all major civil or criminal cases include superior, circuit, and district courts. Appellate courts are the highest level of appeal. Federal court system. Have jurisdiction over all cases that violate federal statutes. Can provide judicial review for all lower state and federal court decisions. Canadian court system. Provincial courts handle most cases that come through the legal system, including but not limited to criminal offenses, family law matters, and young offenders. Provincial and federal courts of appeal hear appeals from the lower courts as well as constitutional questions. Supreme Court of Canada is the final court of appeal from all other courts. Reporting the crime, interactions with the police. First step in entering the criminal justice system. Police focus on what happened, who was involved, where did it happen, and when did it happen. Victim's relationship with the perpetrator and personal history are often reviewed. Need to determine who was telling the truth. May or may not appear to be supportive of the victim. Pressing charges. A criminal act against the state, the victim is a witness for the state. If a crime is determined to be committed, a perpetrator must be identified. A decision about whether to press charges is made by the police. Part of the decision is whether the victim will participate in the court process. Pretrial. Pretrial release. Whether the person charged will be detained or released until the trial. Preliminary hearing, to determine if there is a probable cause to believe that the accused has committed a crime. Grand jury. Hears evidence against the accused and determines if there is enough evidence to proceed with a trial. Criminal justice trials. In the courtroom, based on an adversarial system of law, right of the defendant to see his or her accuser. The jury trial. Members drawn from a group of citizens who sit in judgment of the defendant. Sentencing. Court considers principles of sentencing and legal guidelines on severity of sentence. Capital punishment and death penalty. Roots in early justice systems. 18th century increased emphasis on incarceration. U.S. Bill of Rights, 1791, controlled use of capital punishment. Not abolished in any state until 1950s. Civil justice system. A system of private justice that governs transactions and grievances among individual citizens. Parties are private individuals or corporations. It is the plaintiff's burden to prove the elements of a civil claim against a defendant. If the elements of the claim are proven, the defendant will have to pay the plaintiff. Civil procedures. The victim or attorney can file a cause of action. The defendants are served with a copy of the claim and generally must respond in 30 days or a default judgment may be entered. Defense may file a summary judgment to dismiss the entire case or portions of it. Discovery allows each side to learn the facts and theory that each side is claiming. Liability must be proven by a preponderance of the evidence. Considerations for pursuing civil justice. Control is in the hands of the victim. Payments can be awarded for restitution. Recovery of award is not always straightforward. Victims' history and medical treatments are open to scrutiny. Statutes of limitations. Time limits for filing any suit, example 1 to 3 years. Longer limit with respects to obtaining compensation, example 20 years.